Welcome. Today I'm joined by Michelle Butler and Stephen Hill, both members of R3's General Technical Committee, and we are discussing R3's proposal for changes to the Insolvency England and Wales Rules 2016 relating to fees for CVL liquidators. This initiative comes directly from the difficulties R3 members, especially in smaller firms, face when managing CVLs with limited funds. The core problem? Creditor disengagement. Following the rule changes, we saw a rise in creditor apathy around fee approval. Our R3 survey confirms this. Nearly 30% of cases with funds fail to get fee approval at the first attempt. This forces IPs to spend valuable time and resources just to secure basic remuneration. The solution is reasonable and fair. Introducing a statutory fee of £10,000 plus VAT to cover the essential, non-negotiable work in a standard CVL. This streamlines the fee approval process, reduces the need for costly court applications, reduces court work, and would bring affected cases to more timely conclusions. Michelle, Stephen, thank you for joining me today. How are you both?
Good, thank you.
Thank you for being on. Move straight on to the questions about the actual proposal. So, the R3 survey showed that in a significant number of CVLs with funds, fee approval from creditors failed at the first attempt. 29.59% reported an 11 to 25% failure rate. Why do you think this rate is so high? And can you describe what a typical small practice IP is currently forced to do when creditors fail to vote, and how that disproportionately affects their ability to complete a CVL?
Well, I think, Ben, you mentioned it in your opening statement. There is creditor apathy out there, quite understandably. Most CVLs don't produce dividends, so why should they lift up their pen and fill in a vote pool? But I also think that the profile of CVLs has changed. The number of CVLs now with very few creditors. We're talking about CVLs with maybe just HMRC and a bank. And HMRC traditionally don't vote on fees unless they are expecting to receive a dividend or they get confirmation that they'll get a dividend. So as you say, this does force the IP to ask creditors again. I know some IPs feel uncomfortable kind of canvassing for votes to creditors, specific creditors, trying to get them to complete votes, and I can understand that. But then, of course, the IP is left with the decision, do I go to court? And many cases, there aren't sufficient funds to go to court to seek fee approval. So they're really forced sometimes to negotiate with HMRC and say, well, we'll pay you a notional dividend. Can we get a vote from you, please? Or maybe even just paying the dividend to the secondary creditor, provided there's not employee claims, and being done with it, not taking any fees, which, of course, is entirely unfair. So difficulties that IPs with just these minimal funds in cases are faced with the creditor apathy, not being able to get fees approved.
And I would simply add, not getting a fee at all is itself contrary to the insolvency rules, as the very first thing that the rules say in relation to remuneration is that the office holder is entitled to be paid for his services as such.
Thank you both. I think you touched upon it just then, Michelle, about the court application. So the survey highlighted a significant disparity in costs. So like a minimal CVL costs between £10,000 to £15,000 to complete. Yet a court application for fee approval costs between £5,000, £10,000 or even more. How does the cost of the existing approval mechanisms, typically the court route, become prohibitively inefficient when compared to the cost of a standard CVL? And how does our proposal seek to resolve this?
In a small case, the cost is just totally disproportionate, as you've just said, and therefore a court application in a case with few assets is just not a suitable mechanism. It's something we've been stuck with for quite a long time. The Insolvency Rules 1986 did allow a default to what is now Schedule 11 scale, but that was subsequently removed without any clear explanation as to why it was removed. And we're just trying to come up with something simple to enable basic remuneration to be paid, firstly without that wholly disproportionate cost, and secondly without involving the court in something where the court really shouldn't be involved, because the authorities are clear that the purpose of the court is dispute resolution. If you simply can't get the creditors to talk to you at all, there's no dispute, why is the court involved? Really isn't their job, and we'll happily take this away from the civil courts, which we are increasingly finding are overloaded.
I'd say that, as you mentioned then about the total cost of a standard CVL, we're talking here that this statutory fee that we're suggesting is something just to cover the basics that every IP has to do on any job. This should be not controversial. The initial notices, closing the case. Obviously, you've got to run a bank account in these cases because we're talking about cases with a certain amount of funds. SIP2, CDDA. So all these basic duties are the same for every CVL. So we're not here looking at structuring a fee for complex cases, but just finding a standard, non-controversial fee that can be taken by a CVL liquidator, avoiding pestering creditors or the court.
Thank you, Bag. The proposed new rule 18.19a states that the liquidator shall be entitled to the prescribed statutory fee of £10,000 plus VAT. Does the liquidator need to ask creditors for approval to take this fee, or is this entitlement automatic?
It's automatic. That's actually the whole point of it. That, as Michelle just said, it avoids pestering creditors and then, on getting no reply, going to the court. The amount is designed to be modest and hopefully non-controversial and just cover the basic costs of a decent burial. But if in some exceptional case, actually, the insolvency practitioner did think it was too much, he doesn't have to take the whole of it. But I suspect such cases will be few and far between. And the amount itself is flexible, that we've written into the draft rules that the Secretary of State can change the £10,000 by regulation.
Also, the liquidator doesn't need to be bound by this statutory fee. The proposed changes will enable the liquidator to go to creditors in the ordinary course and ask for a larger fee if they have a more complex case.
If a creditor believes the statutory fee is excessive, are they able to challenge that fee? And how does the proposal ensure that this right remains easily accessible?
We haven't changed that at all in this redraft, so the ability of creditors to apply to court on the basis that the fee is excessive remains. Previous answer. I think that's a highly unlikely scenario because a modest sum has been chosen, but the right remains.
So part 2 of our proposal proposes to remove in the 18-month deadline for an office holder to apply to court to fix the basis of fees. What is the practical benefit of removing this timeline?
So looking at this statutory fee proposal, we did see some other fairly frustrating parts of the fees rules that we thought, shall we just have a little tweak of those as well, just to tidy those up? And yes, this was one of them, because whilst we believe that the regulators have been fairly settled in recent times, that the rule only prohibits CVL liquidators from going to court for fee approval after 18 months. There has been quite a lot of debates in the past about whether that also blocks CVL liquidators from going to creditors after 18 months to seek fee approval. So we'd like to clarify that. There are many cases where the case is just too complicated to be able to propose a reasonable, fully informed fee proposal to creditors within that 18-month period. And it seems crazy to force IPs really to seek fee approval in that timescale if the case doesn't really lend itself to that. And so why not remove the 18-month deadline entirely so that IPs can go to creditors at the appropriate time to seek fee approval or apply to court if they don't get creditor approval for that?
Yes, I think this one is really aimed at the more complex cases. The CVL statutory prescribed fee is obviously the very small case. This is for the more complex cases where it doesn't make sense to be asking the creditors too quickly. And there may also just be cases where there's been an oversight and you don't think to deal with this for whatever reason. Creditor engagement is slow in coming, but it will come. There are various reasons why you might want to go beyond the 18 months. And I think this was introduced back in 2010, effectively under a misapprehension that the government seemed to think that if the insolvency practitioner was merrily working away on the case without the basis of remuneration having been fixed, that somehow put the creditors at risk. And of course, it's the exact opposite. If we're working away on the case without the basis having been fixed, it's actually the IP who's at risk, not the creditors. They're doing all that work and then finding the creditors actually don't want to pay them very much for it. So I think it was a complete mistake in the first place.
Which we're trying to rectify. Thank you. So part 3 of our proposal allows a change in the basis of remuneration to apply to work already done. Can you give a quick real-world example of how this change helps a new office holder who has inherited an appointment, and why the current rule can effectively force the office holder to work for free?
I think this comes really where the new office holder is probably from a different firm from the previous office holder, and a case may change firm either as a result of regulatory intervention on the old practitioner, or simply the creditors voting out the old practitioner because they're not satisfied with progress and appointing somebody else. And if that previous practitioner has a fee resolution based on a set fee or percentages, then it takes the holder to get his feet under the desk and read into the case and decide what's appropriate. The time spent between his appointment and getting the fresh resolution won't be payable because that would be retrospective, which Rule 1829(5) currently doesn't allow. But also, just more broadly, I'll turn the question back. Why is this restriction there in the first place? If the creditors and the IP agree, and there is no dispute, everybody agrees that actually the wrong basis was fixed in the first place, why can't you go back and undo it? It's just a frustrating and pointless restriction, and it just doesn't need to be there.
Absolutely. I think we're proposing a few changes to that particular rule just to make it more widely available, as you say, Stephen. If the IP proposes something that the creditors feel happy with, then that should be fine. There shouldn't need a material change in circumstances, or it could be a change in amount, not just a change in the basis. So there are various tweaks we think we can do to that rule to make it more useful for everybody.
To sum up before we go, can you both explain why you think this proposal is a good idea and the benefits of such a proposal to all parties concerned?
I think the proposed statutory fee should resolve a number of CVLs that are sitting on IP shelves. It will mean less pestering of creditors on these simple cases, these cases where there's nothing in it for them, and very little actually in it for IPs many of the times. I mean, we're talking about a statutory fee of £10,000, but it will clear up the cases where there's only, £200 on their case. So it will enable CVLs to be concluded far more quickly. These simple CVLs could take 9 months to close. At the moment, they're taking 18 months, 2 years to close. So I think it's better for the UK insolvency profession that we can show that we can get CVLs completed far quicker with less cost as well.
Yes, and just as a big picture, as we said earlier, start off by saying that the insolvency practitioner is entitled to be paid for their services as such. The insolvency practitioner is inevitably dipping into the trust funds held for the creditors for his own benefit, and that is quite rightly strictly regulated and controlled. But the quid pro quo to that is that the system for allowing that remuneration must be workable and understandable and also suitably flexible to cope with all sorts of real-world circumstances. And this is just a little exercise in trying to achieve those aims, tidy things up, a little bit of deregulation, bearing in mind that insolvency practitioners are themselves regulated anyway, and therefore the risks of anything going seriously wrong are small. And it's just a bit of simplification and making the world better for creditors and insolvency practitioners alike.
Thank you for joining me today, and thank you for all your hard work on the proposal. And that'll be it for today.
You're very welcome. Thank you.
Yes, thank you, mate.